So one of the areas of law that I get a lot of questions about, sometimes over the internet, and people come into the office and call on the phone a lot for questions, are on expungement of one's criminal record. So expungement is a very important process in the American legal system, and I'm going to isolate it on California at this point. And in California, the expungement process is available for almost all types of crimes. Obviously, or maybe not so obvious, murder and some more serious crimes cannot be expunged. But the general run-of-the-mill crimes, which, I hate to explain as run-of-the-mill, which would be theft, forgery, embezzlement, drug, possession, those kind of charges can be expunged. And the important process for that is to get it done in a timely manner. Even though you're on probation, most likely, for your offense. Probation is usually 3 to 5 years in California. Most of the time, the judges, if you're moving ahead with life, showing you're gainfully employed, showing that you're doing the right things in life, you may not even be done with your probation yet, and the court will allow or entertain an expungement motion to eliminate that from your criminal record. So no one would know about that. When you go apply for a new job, you apply for credit, you do things that people want to know about your background, this expungement process will allow that to not be on your record. You won't be required to tell people about it once the expungement process is finished. What happens is we file an application with the court, where County Law Center will assist you to do that. We file it in the court of law where the offense occurred. So whether it's San Diego County, Riverside County, the expungement needs to be filed in the county where the offense occurred. And we show the judge that the person who's getting expunged has either completed their probation successfully, has no prior record, no additional record other than the one we're going in for, and nothing's happened since then. And we're able to convince the judge to terminate the sentence, reduce it either from a felony to a misdemeanor and then expungement, or if it's just a misdemeanor offense only, the expungement happens almost automatically. If it's a felony, we need to file a motion to reduce to a misdemeanor, and then the misdemeanor is expunged. So either way, the record would show no history whatsoever of criminal background, which will allow the person to go forward with life and move on without that hanging over their head. The other offense that people ask about expungements on or with is a driving under the influence or drunk driving, or nowadays with legalization of marijuana, we're going to see a lot more marijuana, driving under the influence of marijuana charges. So the only issue with that is the priorable offense. A DUI or a driving under the influence is priorable for 7 to 10 years. So you usually cannot convince a judge to expunge a DUI when it's a driving offense, because the DMV's involved, until that 10-year period is up. After the 10 years, it can be expunged. There are certain circumstances with the necessity. Let's say you're trying to get a job that's going to require a background check, and that DUI is going to make you can't get that job. That may be the possibility. With County Law Center to help you, we could convince a court to expunge your record, even though your probation was still around, or even though your 10-year period for a priorable offense hadn't run. If we show exigent or emergency circumstances, that can be done as well.